Hello everyone. So it's 4:30, so I'll start the webinar now and just say hello, welcome to everybody for joining us. Thank you for joining us at this FMB webinar that's been recorded on the 26th of January 2021. Hope you're all well. And we've got good attendance booked today for this webinar because I think that the subject matter in terms of dealing with disputes and preventing them from ending up in court is something that we know members do struggle with. And so I'm sure it'll be useful content that Sarah shares with us today. And this is the 7th in a series of 8 webinars on contracts, which will all eventually be available on the FMB website in the members area if you want to catch up with any other of the webinar sessions. If you're new to these webinars, just to let you know, we'll send out a follow-up email and that will have copies of the slides attached, so you don't need to take detailed notes throughout unless you want to rather. If you've got a question for Sarah, our speaker, please just pop it into the Q&A box at the bottom of the screen and we'll deal with questions towards the end of the session, which should take about 45 minutes in total. So I'll now hand over to our speaker today, who is Sarah Fox, the 500-word lawyer. And if you're wondering why she's called that, it should become clear during the course of the webinar as she talks about simplifying contracts. Over to you, Sarah. Thank you.
Thank you, Hayley. And I'm just checking that you can see the slides.
Yeah, could see those fine, thanks.
Lovely. So as Hayley said, we're going to talk about your remedies. So what can you do when things aren't quite going to plan, when you're not working well together on the project? And contracts are a major part of sorting these things out in advance, about thinking them through as to what you would like to happen. I'm not saying that you should always plan for how you're going to break up, but actually it's much easier to do that in the giddy stages of the beginning of a relationship than it is to do it when you're bitter and at each other's throats. I'm thinking that's more like a personal relationship rather than a business relationship. But if we can draw the same analogy with contracts, it's really useful to use a contract to set expectations, to explain to a client what the remedies are, explain how you can both avoid going to court when possible, and so that you both can read, use and understand everything that you need in this contract. So we've been through a number of sessions, as Hayley says, they'll all be available. In the first session, we looked at the importance of simplifying your contracts and why the FMB went through a project with me to simplify their contracts. And that was largely to give you confidence in using them, that you understand them and you really get how to complete them, that they will properly safeguard your business by being really crystal clear what you have to do and what the other your client has to do, and to help you avoid disputes, because disputes, although sort of an inevitable part of doing business, can be minimised wherever possible. Then in sessions 2 to 4, we kind of looked at some of the critical items you need to write into your contract. We looked at the who, the what, the when, the how much, the what standard and the why. So if you want to know more about those, have a look at those sessions. And then in session 5 and 6, we looked at managing risks and making sure you're not betting your business on a project, limiting your liability and the importance of those things. So in this section, we're going to look at what you need beyond the bare minimum in a contract. And that's about creating an effective contract, one that works. So when we say effective, we just mean one that works for you and works for your clients. Because you've got a contract that meets legal requirements, it needs to be a little bit more in depth if it's going to really work for you. So, Hayley, I wonder if you could launch the first poll for me, please.
Well, we've got about 2/3 of the votes in, so I'll end that poll there and share the results on the screen. And it's fairly conclusive.
Yeah, that's pretty conclusive. And actually, you're right. It's most efficient, the cheapest and the best for your long-term reputation to have a good client relationship, to resolve or nip disputes in the bud as before they become disputes. So anything that comes from a sort of an issue can be resolved through good client relationships. And although your contract can help build those relationships, it can't replace them fully. So as we looked at in the last session, we looked at the things that your contract needs. So we looked at procedures, risk and liability. In this session, we're going to look at how we can avoid the courts by using contractual remedies, how cancellation can help because it gives the client confidence that they can get out of a heady deal that they might have entered into accidentally, and also how you can get out of it when it really has hit rock bottom, and that's termination. So remedies are really useful because every remedy that's written into a contract, and we'll talk about some examples so you understand what I mean, it helps you to avoid the cause. It helps to keep building and keeping that client relationship. They're a quick fix solution. So you don't have to then prove that there's breach of a contract, that you've suffered loss, that's loss, how much that loss was, all that kind of stuff. If you were bringing a claim in a court or adjudication, that's the sort of information you'd need to provide. But once you've got remedies in your contract, you need to use them where appropriate. So burying your head in the sand and hoping it'll all go away is also not the right approach. So first of all, we're going to have a look at some remedies that you can't avoid. These are statutory remedies, so they're imposed by legislation into specific types of contracts. And there's two different types of legislation that will apply to you depending on the type of clients you have and the type of projects you do. The first one is consumer remedies. So that's anyone who is having works done to their main residence and they're not acting in the course of a trade or a business. So this is not property developers, or this is not serial property owners who kind of treat it as a business, but this is a true consumer. And under the Consumer Rights Act 2015, they have various rights as consumers. So they can cancel the contract within 14 days without cost, and we'll talk about that in a bit more. Your contract has to have a complaints procedure, and that's using the FMB's dispute resolution service. They also have remedies, so they can ask you to reperform works. And that's pretty much what we'd have in a construction contract anyway. We'd have a defects remedy. And then there's also got rights to refunds if you can't reperform the works. Now, refunds are a bit trickier when it comes to construction projects because obviously most of the goods, works and services have already been provided. So refunds are less relevant to the sort of works you do, but they're still an important part of the consumer remedies. And then if we're not talking about consumer, we're talking business to business, then the Construction Acts and various other bits of legislation apply. So you should be aware that you have a right to charge your client interest if they pay you late or if they don't pay you at all. And that's an important remedy. But on top of being able to charge them interest, you can kind of up the ante slightly by saying that you've actually got a right to suspend carrying out works or services if they haven't paid you. And that's under the Construction Acts. You do have to give them notice. You have to give them 7 days notice that you're going to suspend. But once you do that, the extra cost of taking yourself off site and coming back again and the extra time involved are automatically added to your contract terms. So you shouldn't lose out. But a lot of the industry failed to use suspension because of the reputational damage it would create. So they didn't want to walk off site and get a reputation for being tricky to deal with. So suspension is an underused remedy, but it's still a legal remedy that you have. And then you can take disputes under construction contracts to a form of process, a dispute resolution procedure called adjudication. And we'll talk about that briefly in a bit. So as I've done in previous sessions, I've given you examples of how the remedies are set out in the different contracts from the FMB suite. And these are talking about remedies for defects. There's also remedies in relation to interest on late payments is included, adjudication is included in the commercial contract. So all of them are wrapped up, but these are just examples of where you might see them. So it's really important that contracts are workable for the construction industry, because what we don't want is sort of nitpicking clients. And this has a real historical basis. So about 150 years ago, construction contracts were considered to be an entire contract. Now, that's a bit of really quite specific legal jargon, but basically it meant that until you provided everything in the contract, the client had a right not to pay you anything. So there was no payment by installments or stage payments. And if you had a particularly pernickety client, maybe Mr. Fussy from the Mr. Men books, then you wouldn't get paid, even though you've provided 99.9% of the scope of works. And the courts looked at that and had said that was inappropriate for a construction contract, because that meant that they could use minor defects to stop paying for something that they then had the benefit of. So we have this concept of practical completion, that everything doesn't have to be perfect as long as it's usable. So Mears and Cosplan was a court case from last year that looked at practical completion in terms of failing to meet a scope to the very letter. And it was to do with provision of student accommodation and the size of these student accommodation units when they're completed, which were less than they should have been. But they looked at that and they were talking about the fact that practical completion means if you could still put a student in that room, it was still fit for human habitation or student habitation, then it wasn't defective. You couldn't reject it. You had to pay some money towards it. And it's a really important concept. And it has to say, it is a concept that a lot of clients, particularly consumer clients, don't really understand. They don't understand that they're not going to get perfection at the time it's complete. They should get close to, but they should be maybe a few hairline cracks, bits of plaster that still needs to be redone. So all of these things are really important for clients to understand, so that they understand what the process is really like. Now, Stella Rimington, who was the former Director General of MI5, was talking about the Thames House refurbishment in London. And she said it was clear that dealing with the building industry was as tricky as dealing with the KGB. Now, I think that's probably a rather mean thing to say about the industry, because we're all interested in making sure that we make a difference to people's lives. So the purpose of remedies is to stop mean people taking advantage effectively. So we have a wide range of contractual remedies, all of which are quicker, simpler, and cheaper to use and to rely on. So they're really a win-win for both parties to the contract. They're not just for you, they're for your clients as well. So the typical remedies we see in construction contracts are things like extensions of time for unexpected events, and we talked about that in a previous session. You might get loss and expense for disruption, a typical remedy under JCT contracts. The right to change the scope, which we also talked about in an earlier session. You can get final payments or retention monies to cover unresolved defects. Now, we've tried to move away from retention because it's got a poor reputation as being a stick to beat contractors with in contracts. And there's quite a big groundswell that says retention should be abolished, because it's effectively a way of a client getting a benefit, because sometimes they just never pay it. They always argue. So it's a slightly contentious issue, but it's one of the ways that clients can sort of give themselves a bit more confidence that you're going to come and sort out anything that's outstanding. We have delay damages for late completion, which we have talked about in a previous session. We've got defects periods where the quality of the finished works isn't quite right, or there's things that don't work. We've also got remedies for cancellation and termination, because without contractual remedies, it's extremely difficult. I'll show you an example later in this session so you understand how difficult it can be to prove that you've got a right to terminate without a good contractual remedy. And then we might also have dispute procedures written into the contract, or route maps for resolving your issues. So really important that we understand how these remedies work. Now, I know you're not in the business of selling and probably not in the business of buying luxury yachts, but there was an important case to do with the Azimut Bonetti Group, which looked at a contract between a multimillionaire, Mr. Healy, and the Azimut Bonetti Group, who were providing him with a super yacht. Now, super yacht, there are no sales. It's not a gentle thing. This was £100 million worth of what I would call a floating gin palace. But Mr. Healy wanted a right to cancel the contract at any time, and the providers of this yacht were saying, well, if you cancel before you've paid any money, that would seem unfair because we might have put a lot of money into starting to build your bespoke yacht. So they did a deal and they agreed that he would pay a quarter of the contract price if he wanted to cancel before the first payment was due. Now, the first payment was also coincidentally a quarter of the payment, the project price. And lo and behold, Mr. Healy did decide he didn't want a £100 million super yacht. Maybe he'd had a bit of a shock on the stock market, or maybe he decided to buy an island or a football club or something. But the providers said, well, that's very well, Mr. Healy. We understand that you don't want this yacht anymore. However, we now want our £25 million. And he was very unhappy with having to pay the money that he'd promised to pay them if he cancelled. He didn't seem to quite understand this. And when it went to court, the court said, well, you're a businessman. That's probably why you've got £100 million just lying around for a yacht. So you've promised to pay them £100 or £25 million if you cancel. You have cancelled. You have to pay £25 million. That's the deal that you negotiated. We know you negotiated this clause. So effectively, stop whining. And it's really useful. And one of the things we did when we rewrote the FMB suite was to make sure that clients would understand what their remedies are. So they did know what they could and couldn't do. So they had that route map set out for them, because we didn't want misunderstandings to make it tricky when you're already in dispute or got a complaint. So we've come across this property before, and this was a client who was splashed all over the news a couple of years ago. It was a new build property in Norwich, cost £350,000. The owners had to move out 3 times to allow the contractor to rectify defects. And it was obviously a sign of really poor client relationships that they got to that point, and that it had been splashed all over the press. So a real problem with lack of trust, lack of understanding of their remedies, and probably lack of following the contract properly, because if there were that many defects, it should never have been certified as complete and they should never have moved in. So why do we need to include remedies in contracts? Well, I think you've probably have got the kind of gist of this, is that it sets out a pre-agreed route to resolve an issue. And that's really useful when you're kind of flapping around like a fish, not knowing what to do, and your client doesn't really know what to do. It gives you a pre-agreed route. They're simpler, quicker, and cheaper to use than going to court or even going to adjudication. And there's a much greater certainty of the cost of following that remedy, the process, and the outcome. And that's the whole purpose of contractual remedies, is to give you that certainty. If there are no remedies, then you do have certain rights under statute law, you have certain rights under implied terms, and you may be able then to use the dispute resolution processes of adjudication and litigation. But they're going to be costly. There's no certainties as to whether or not you succeed in those things. And you're going to talk at least 2 months probably for adjudication, and at least 6 months and maybe years if you went to court. So none of those are really very attractive propositions. So that's why we include remedies in contracts, because it's quick, it's cheap, it's easy, and it sets out a really clear, certain process by which you can resolve these issues. So remedies differ according to where you are on the contract scale, so where you are in the timeline. So some of the remedies are very much time dependent. So the client's right of cancellation is only for 14 days from the time the contract is signed. After that, that right ceases to have any effect. They don't have that remedy. There are different remedies during the works period. So the remedies of things like extensions of time, changes, loss and expense, that kind of thing. Then we end up in the defects period. That's obviously a key point at which we start looking at quality remedies. And then we might have the limitation period. Now, that's either either 6 or 12 years under English law from the date of completion of the works. So they're really important that you realise that the remedies do differ according to the periods that you're in under the contract. So when it comes to cancellation, now your clients may believe, admittedly wrongly, that they have a right to cancel your contract for reasons such as the project going over budget, losing faith in you, or getting a cheaper quote. But the FMB suite allows them to cancel really for the rights that they're entitled to under the Consumer Rights Act, or for the short form contract, they're also entitled to cancel for just effectively on a whim. Now, the reason cancellation is important is because it goes over the right to finish that we've talked about before, which is a contract binds you to carry out the whole scope of the work and binds a client to pay for that whole scope. So you have an obligation to finish, but you also have a right to finish. To take that away by cancelling willy-nilly or without a good reason kind of goes against the legally binding nature of a contract. So it's really useful to remember that you have a right to finish the works, and any form of cancellation should help compensate you for that. So when we look at the cancellation terms in the short form contract, you can see that the first paragraph on that screen talks about the right to cancel within 14 days, and that's a right under the Consumer Rights Act. We've also added a right to cancel the project once the work has started on 1 month's notice. Now, 1 month can be quite a long time when you're actually only doing one of the short form contract projects, but also that they have a right to cancel, but they have to pay all the costs you've incurred to date, as well as compensation towards your lost profits. So you don't actually have to carry out all of the works, but you will get paid for the works that you don't carry out. You'll be paid your profit element. Now, under the contracts, the consumer and domestic ones, which are for larger projects, then they only have a right to cancel within 14 days without having to provide a reason. After that, we're talking about a termination right. See, if you've got a short form project, the sort of project you put under a short form contract, it could be a bit stubborn and pig-headed to expect the client to continue to work with you or force them to allow you to get access to the house if they've completely and utterly fallen out with you. But it's really important that we don't allow them to frivolously change their mind and just get away scot-free without compensating you. So that's why it's important that they pay for the privilege of cancelling a contract. And this can really focus their mind as to whether they really do want to cancel the contract or whether they're just trying to get some sort of leeway, some leverage about something that's happened. There isn't, as I said, the equivalent right to give just notice and pay lost profits under the consumer or commercial and domestic contracts. So, Hayley, could you please launch the second poll? So I'm interested really in your knowledge of consumer rights law, because I know that as a consumer myself, I have seen a number of contracts sent to me, not by FMB members, but from different trades who had no reference to my right to cancel the contract. And if I'd said I have a right to cancel, they might have looked at me rather shocked.
So 2/3 of people have answered that question, Sarah, so I will share the results now. There you go. Hopefully you can see that.
Yeah, I can see that. So I'm hoping that you now begin to understand it. There are guidance notes in the FMB contracts talking about their right to cancel, and the contracts themselves go very clearly through the process the client has to follow in order to cancel the contract effectively. They don't actually have to do it in a specific format, but you have to be able to they have to prove that they did notify you. So if you have a look at the contracts, if you read them through, you will follow the process. You'll understand exactly what your rights are and their rights are too. Because if during the 14-day period they've asked you to start work and then they cancel, they do also have to pay your costs. So if we're not talking about cancelling in the 14-day cooling off period, as it's called, or we're talking about cancelling and compensating you, then we're talking about a termination provision. And when I say termination, I mean because one party is in default. They've done something wrong under the contract. It is a key remedy for contracts because you can't keep going forever and banging your head against a brick wall. It is, however, a very serious step because it stops you carrying out the works and it stops a project in its tracks. You really only want to rely on termination when your relationship with the client has broken down irrevocably. But it seems to me that all contracts should have a right for both parties to terminate. And I have seen too many contracts which only allow the provider to terminate, but not the client, or vice versa. And actually, if your client is not paying you, why would you want to continue going to the site? Because you're just throwing more good money after bad. So the termination provisions that we have look at from either side. So the short form contract has pretty much a brief mutual obligation, which basically says if either of you are in serious breach, then the other can ask them to rectify. And if they don't, that terminates a contract. Under the domestic and the commercial ones, they're slightly different, but they've got more sort of scope for what serious breach might be. So that could be stopping work for 14 days in a row, so leaving site, suspending works, abandoning the works as it's referred to, failing to turn up for work regularly, becoming insolvent, or all the different means of going insolvent, or failing to complete the work within the work period as extended. Now, it's unlikely that clients would terminate for delay, but if you continued not to finish the works, then they'd want a right to be able to call it a day at one point or other. See, a contract should have a mutual right to terminate. So there is a right for both parties to terminate in all the FMB contracts. It should have clear trigger events. So it should explain on what basis you'd be allowed to terminate. So serious breach or suspension without cause. It should have a mechanism to notify the other party, because you ought to let them know if you're going to cancel, effectively terminate the contract. There should be a time period between when you first notify them and when you can then terminate. So you may want to give them immediate notice, or you might want to give them an opportunity to restart work for, say, 7 days. And then you should look at how outstanding payments are dealt with. So all those things are important in a termination provision. Now, if a contract says nothing about your right to terminate, then you have to prove what's called fundamental breach. It's also known as a repudiatory breach, but that's a term that not many lawyers can actually define with any clarity. It's not simple to prove fundamental breach. And there have been cases, in fact, even the Wembley Stadium, the Wembley Football Stadium in London, had a case between the main contractor and its steel subcontractor for termination, where both parties thought the other person was in fundamental breach. And it wasn't until they got to court that they found out which of them was right. But really, once a collaboration ends, if you can stop trusting each other, stop working together, stop sharing information, giving access to your premises and everything else, you really ought to have a means of getting out fast and with your sanity intact. So as I said, it's simpler, quicker and cheaper to use than going to court to prove fundamental breach. And it's much more certain. It says who's going to pay whom. It says what the notice provision is. It says what triggers it, all that kind of stuff. So much clearer and easier. So here's an example of a project. This wasn't the right house. Actually, it was a house on the other side. But I was trying to find a picture of a property that was similar on the same road. But there was a case to do with an extension for a property in St Albans. And the works were instructed, but with no real clear payment terms, or the price hadn't really been settled by the client. So a few months into the project, there was £17,000 outstanding. And then by October, that had risen to £40,000. And the contractor wrote to the client, and the clients were basically turned around and said, well, we don't really have any money. So the contractor wrote back and said, well, okay, you've got some financial embarrassment. They said they'd had some problems with stocks losing value. They were refinancing, et cetera, but they'd been talking about this between August and October. And they said, the contractor was saying, you're basically not paying us. We've been patient, but now we need to get paid. But some of the money had been outstanding for 3 months. And the contractor said, we're happy to return to work if you settle the outstanding balance. And the client couldn't or didn't settle the outstanding balance. So the contractor basically decided to walk off site and said, well, if you can't pay us and won't pay us, then we don't see that we ought to finish this job. And the client kept saying, well, if you come back, we will make sure that we pay you in the end. It's like, well, hang on, we're £40,000 out of pocket. How long do we have to wait? How patient do we have to be? So it went to court, and the court looked at the circumstances between the parties. And they said, actually, although there was nothing in the contract about money, the contractor was entitled to be paid a reasonable sum within a reasonable time. And they said 14 days was a reasonable time for stage payments. Said, in fact, the quote was, I do not consider that more than 2 weeks at the outside would normally be required to pay an invoice. So invoices should be being paid within 14 days. Well, that's quite an interesting piece of judgment from a court. Said, by not paying the invoices in October, they were in breach of contract, and their financial difficulties were not an excuse not to pay. They actually had to find the money. They couldn't just keep pleading these financial difficulties. But they said that by the end of October, the clients were simply not prepared to make any further payment, even if they'd had the money. So it wasn't just that they were saying, we haven't paid, but we're not going to pay. And that, the court said, was a fundamental breach. And that's their obligation, because that is what is to you the most important term of the contract, i.e. money. So this was a case where the court decided that the contractor was entitled to stop work, walk off site and leave the client with part finished project because they simply weren't getting paid. Now, although those cases are not entirely rare, not many of them actually get to court in this sort of way. And it's much, much better. And I think the parties would both agree that what they should have had was a clear, simple contract at the beginning, which said how much was going to be paid, by whom, when, and what their rights were if they weren't being paid. So just one final poll for you. Just trying to find out whether you've ever had to terminate a contract with a client.
There we go. I think everybody has voted who's going to, so I will share the results with you now. Good that nobody's doing that regularly.
Absolutely. And I suspect nobody really wants to terminate contracts with clients, and it's a painful feeling. I know that I've had to terminate a few myself, but it's good to know that you have the right to, even if you don't use that right sometimes. So really the upshot of this session is to say that you can use the contract and the remedies in the contract to take control of issues before they end up either in court or in adjudication. And you've already shown that the client relationship is absolutely critical to that. And a good contract can actually build on your good client relationships by being very clear what both parties have got to do. So I don't think contracts are a replacement for a good relationship. I think they enhance a good relationship by adding clarity and simplicity and adding these procedures which can really help you to avoid courts. So that's all I've got to say in terms of the session. Have we got any questions?
So only one question so far, but I would encourage any members who've thought of a question during the webinar. No such thing as a stupid question, of course, so please pop it in the box and I'll share it with Sarah in a moment. But I did just want to mention as well that as FMB members, you're all entitled to use the FMB's dispute resolution procedure, which acts as an informal mediation process over the telephone between one of our members and their client, where they've been unable to reach a solution to an issue themselves. So sometimes it can help just having an independent third party on the phone to talk about what the best outcome would be for both parties. It's not a legally binding outcome that is produced through that informal process, but we can also refer cases on to CEDA, the Centre for Effective Dispute Resolution, who can produce a legally binding outcome statement, which is useful in more complex and larger value cases. So there is that service available there for members and their clients. And so I hope, if you take a look at the FMB website, you'll be able to find the dispute resolution page quite easily. One of the questions we've had is in relation to that. really, because one of the things that the FMB service does not do is deal with a dispute where it's purely financial. So if the client's not happy with an aspect of the work and they are trying to negotiate a financial sort of settlement between both parties, then we don't get involved with that. But this attendee is asking where there is a financial only dispute, which doesn't fit within the remit of the FMB scheme, is the only suitable remedy to put in a contract seeking legal advice or begin legal proceedings. I guess it's preferable if they manage to negotiate it between them, Sarah, isn't it?
So the answer is that although a contract can set out what your options are, you can actually do anything you like that you can get them to agree to. So the first course is always to negotiate. And as what somebody's put in the chat, negotiate until you're blue in the face if it requires it, because that's the easiest way to avoid more serious proceedings. You can refer any dispute to mediation yourself through the Centre for Effective Dispute Resolution in London or through any other mediation service. You can also go to the Small Claims Court, or you can appoint independent parties to assist you. All of those things, of course, cost money, take time, and may require you to have legal representation, or may be easier, should we say, if you have legal representation. So if you have a dispute, you can resolve it yourself, or you can get other parties involved to help you resolve it through either formal or less formal proceedings. And sometimes just having an independent person who can sit and listen to both sides, listen to what's gone on, and come up with what they think are some solutions is a valuable use of your time. Because quite often, one of the things I used to find when I was involved in mediations was just getting it off their chests, and having somebody listen and acknowledge what they'd been through was a really useful part of the process. And CEDA will say that roughly 80% of mediations either resolve on the day or within a couple of weeks thereafter, so that they are extremely successful ways of resolving disputes. But they cost money, and therefore the value of your dispute is often the limiting factor for all these sort of claims resolution procedures. And it's an issue that a lot of the industry has, because £10,000 is often not a lot when it comes to court proceedings, but it's a lot of money when it's money you're owed and somebody else isn't paying you. So there are other ways around it. You don't have to go to court. And I can think for a lot of the cases that FMB members are involved in, that it's just not financially worth going to court. But getting some decent advice, and even getting a well-crafted letter from a qualified solicitor who understands construction disputes, can also produce very effective results for somebody who's just kind of messing you around rather than being legally correct, shall we say.
I would guess that a lot of consumers kind of bank on that, don't they? They think that the builder is going to write it off.
Cave in.
And that's what they're banking on when they're withholding that final payment. Something that we see quite often is builders will withhold final certificates for things like electrical work or anything that needs to be certified in lieu of getting that final payment. But we don't think that that's a good course of action, because they are obliged to hand them over under the law. So what would your advice be in that situation?
Well, I can see both sides of that argument. I know that there are cases where people have paid all the money and then not got the certificates, so then they feel hard done to, and vice versa, where the contractor has provided certificates and then not got paid and feels like that was the last bit of leverage they had. So it's a very tricky situation to be in. Establishing a decent set of staged payments, making sure that your client is kept up to date with costs and stuff like that, and that you keep on top of those little niggles, because it's the little niggles that kind of snowball into bigger niggles and disputes. That's, as all the people on this webinar have already said, maintaining that good relationship is by far the best way of avoiding and resolving disputes as you go. And sometimes when you get to completion, sometimes people act irrationally, because clients, particularly clients who are living in the property, are so emotionally wound up with this project that they can't see the logical, rational explanation. So, sometimes just at least having someone who writes a letter on your behalf that says, actually, we'd like to give you these certificates, but this money is outstanding. We won't withhold them, but please make sure that the money is received. that kind of can be just the nudge that says, oh yeah, this isn't about me, this is about what the contract requires. So let's take it away from the personal, which it becomes quite quickly, and into the more objective and rational.
Okay, thanks, Sarah. Another question that has been submitted that I'm struggling to open from Christian. Christian's just commented that he'd used the FMB mediation process and that was successful for him, so that's good. And his comment about withholding certificates says it's often the only way to get noticed as a small player, and we've used this many times to make sure we get timely final payments, and it's always worked. So yeah, I guess that's, as you were saying, strictly speaking, under the letter of the law, it's not advisable. But however, if it works, then I can see why.
Well, the thing is, there's a kind of the difference between what the law requires them to do, in which case the Crown can bring a case against your members, and what the contract requires them to do. So we're talking that the overlap between the two can be quite complicated, because the law requires them to hand them over, but the contract doesn't, in that sense, because it's part of the whole carrying out of the works. That includes all the certificates and everything else. And strictly speaking, the client isn't entitled to the whole of the works until they've paid for the whole of the work. So there's kind of there's layers, and the likelihood is, as you know, your members have said, the likelihood is that the legislative bodies aren't going to come against you, the HSE and the building regulations and the local authorities, but the client is the one that is interested. So yes, it can be a very powerful leverage tool, but just use it a bit wisely. Just be careful.
Yeah. There's a comment from Marta in the chat box there about she had to terminate a contract, tried everything to keep the peace, but in the end had no choice but to go to court. I don't know when that was, but they're still waiting for the final hearing. So that's just demonstrating your point that the court process isn't a speedy one, is it? And I dare say that court processes are even slower at the moment because of all the COVID regulations. So
yeah, very much so. And cases are taking a very long time to get resolution, and it can be very wearing waiting to find out that you were in the right or that you weren't in the right, and waiting then once you have got a decision to get paid and everything else. So it should, I'm sure Marta only used it as an element of last resort, and it is very frustrating when you get to that position. But the reality is that a very, very small proportion of projects ever start proceedings, and of the proceedings that are started, about only 2% ever end up in a final hearing. And that's partly because the process just grinds people down, I'm afraid to say. And I'm sorry, Marta, if that's your experience. It's an unfortunate fact of doing business, I think.
Yeah. Someone's asked if using an ADR process sets you in good stead for legal proceedings, even if it's unsuccessful, to show that you're trying. So,
So there's two things an ADR process can do before legal proceedings. One is it can resolve the majority of sort of niggly issues and then help you just focus the legal proceedings on what's left. So it can cut out through some of the sort of detritus that's kind of been attached to your issues. But also, yes, there's a case that under the civil procedure rules, there's lots of things that say that the parties should attempt to use an alternative form of dispute resolution before they go to court, and to save the costs of legal proceedings and the time and all the energy that Marta is talking about having been involved in those legal proceedings. So yes, it does put you in a better position, both financially often, but also, in terms of the issues, but also in terms of costs that might be awarded after the litigation.
Yeah. And just to be clear for members, when we talk about ADR, we mean alternative dispute resolution. So things like mediation and adjudication and anything that's not going through the court process, really.
Yeah, absolutely.
All right. Well, I think we'll leave it there for today because no more questions in the box and we've used up our allotted time. So thank you very much, Sarah, for that really useful session. The next one on contracts is on the 2nd of February. So members who've attended this one will be notified of that as well. And then after that, we've got some webinars on different topics, including 16th of February is reverse charge VAT, which comes in on the 2nd of March. So we'll have a taxation expert answering questions about that. 2nd of March, we're looking at the Green Home Grant Scheme again and trying to demystify that. So good luck to us with that. And then 16th of March, we're looking at different types of estimating software, the pros and cons of those. And we've got a webinar about HR, dealing with employees and managing your workforce on the 30th of March. So there's a full program of webinars coming up, all of which are going to be useful for members, I'm sure. So I've just seen a question pop into the box. So before we close, it's a comment actually from Marta saying, thank you both for this session, which has been very useful. So thanks, Marta. It's good to know that we're providing a useful service to members. Yeah. Thanks again, Sarah. And thanks to all of you for attending. Stay safe and we'll see you next time. Bye.
Bye.